Hi, I'm your friendly lone wolf, and this is January 17th, 2026, and you're watching the Court Gallery. Oh, let me get everything. Hey, guys. Yep, that was me. So, tonight on the Court Gallery, I've got a lot of stuff. Mainly, we're watching Judge McNally and Judge Simpson. That's what we're all here for. But we're starting things out in Bexar County, Texas, with Judge Boyd. We haven't seen her in a long time, and she's got a couple of parents who are showing up to a 19-year-old sentencing, and they really don't want him to go to prison, but we'll see what happens. It's Judge Boyd. You never know. You just never know. A lot of you may have seen some of the McNally that happened today, but you haven't seen all of McNally that I've put together, and you may have seen some of the Simpson that I have put together, but you haven't seen all of the Simpson that I have put together, so stay tuned. There are McNally and Simpson hijinks ahead. Following that, we're going to put ourselves in Wyandotte, Michigan to visit good old Judge DeSanto to round out the night, where she's got a couple of people who I really need a good talking to, and no better judge for it. So say hi to the pups behind me and get ready, buckle up, it all starts right now.
The court is calling 2025 CR 011309A, 2025 CR 011020, and 2025 CR 011311C, State versus Adrian Isaac Hernandez. Can I have parties approach and announce for the record?
Melissa Christian for the defendant.
And are you Mr. Hernandez? All right, you entered a plea into each one of these cause numbers. In the cause number 2025 CR 011020, according to your plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. There's no application for community supervision. The state is opposed to your deferred adjudication, and this is to run concurrent. All right, off the record, we appear that we're missing some cause numbers for me. So this is running concurrent with 2024 CR 007176. Was that a motion to revoke or something?
7176.
All right, and has that already been taken care of or no?
He entered a plea of trip.
And then we have 2025 CR 011020. That's this case.
That's right.
And then 2025 CR 011309A. And okay. All right, I see where we are now.
Okay.
Thank you. All right, so we're back on the record. And then in cause number 2025 CR 0113111C, according to your plea bargain agreement in that cause, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. All cases are running concurrently. And then the state is taking in consideration 2025 CR 0113110C and 2025 CC 009777. And in the cause number 2025 CR 011309A, according to your plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. All cases will run concurrently, and the previously mentioned cases will be taken in consideration. And in both cause number 2025 CR 011309A and 2025 CR 011311C, there's an affirmative finding of deadly weapon. And each of the cause numbers, have both parties had a chance to review the PSI report?
Yes, Judge.
Any objections to the PSI report from either party?
The only thing we'd like to point out, Judge, is there was some question about whether he had prior gang activity, and he does not. I think they checked that he did, but they did say it was questionable. And he is telling me he has never been in a gang.
And state, do you have any witnesses?
No, Your Honor.
Defense, the court has reviewed the letter from the defendant, which is the court's understanding that the state had no objections. So I've reviewed that letter. Defense, any witnesses?
We do, Judge.
All right, you may call your first witness.
We would call Mr. Hernandez's mother. You're up against the counter.
Hello.
Hi, ma'am.
Hi. Could you raise your right hand for me, please? Do you
Yes,
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Giovanna Magaha,
All right, I'm sorry.
Giovanna Rebecca Magaha,
Could you spell your last name for the court reporter?
MCGAHA.
Thank you. You may proceed.
Mrs. Magaha, how are you related to Adrian Isaac Hernandez?
I'm his mom,
Okay, and how old is he?
19.
Okay. And could you tell the court where you live
I live in Smiley, Texas,
and what county is that in
Gonzales,
of that town?
in between, I think, like 500. I mean, it's a small town, nothing's there.
Okay.
Like 2 schools and a Dollar General.
Okay. And if the court were to grant probation to your son, is that where he would be living?
Yes,
Okay. And there's a school there for him to attend?
yes.
Okay. And could you tell the court why you believe that Adrian should be on probation?
This ain't an eye opener. I'll be the first to. I've been praying hard, and with my faith and his faith, I mean, we've been just striving a long road. But I know God is good. I got my family all in church with prayer and faith. And I got my mom home with me too. So, and I feel also changed. So I'm learning new things too. But they're all going. We have actually a lot of our families together still, and peace. I'm missing peace.
So, Mrs. Magaha, the court's going to want to know how it is that Adrian kind of fell off the path and how you're going to get him back on the path.
Well, I have a day and night with me and my husband, and I always take him. That's why I work at night, so I can take appointments for all my kids. So I can deal with that part in the morning if needed. Finances, I know how we're able to finance if we need help with that. There's people that can help us if needed. Finance wise, Or I do try to do overtime so that I can achieve those funds to be able to put that there as well. And then the church has been very helpful and helping us with our children, as well as the school that my children are in, with support and helping us with organizations outside of school to get them in right structure with speech, or any things that they're needing for their health issues or mental states as well.
And was your son in special classes?
Yeah,
Okay, is that a 504 designation, do you
that
know?
was one of them. And he did have also behavior from his ADHD and stuff like that.
Okay, and how high did he get in school?
Well, he repeated ninth grade for a good minute. But they ended up passing him through to 10th grade, but that was the last of it. But they only found record here when he was trying to go for GED only for the 7th grade. So we would have to find a way again, which is very possible, to be able to do so.
And you're willing to do whatever it takes to get him back on track educationally?
Yeah, I mean, I have been, and I haven't let go yet. I'm still here.
And if the court sees fit to grant him probation and puts your son in different programs to try and assist him, will you all be able to transport him or
Oh,
do
yeah.
whatever is necessary?
That's what I do for my kids, though.
And how many other children do you have?
I have 3,
And what are their ages?
5, 4, and 16 months.
We'll pass a witness, Judge. Hang on.
I have a couple of questions for you. Okay, so you stated that you live in Gonzales County, Texas, is that correct?
Like the outskirts of it.
Okay, and how long have you lived there?
Going on 6 years.
So what year did you live there?
2020.
2022 or
The month I don't, but I know the year is 2020.
20? Okay. And so regarding your son, I mean, he's 19 now, but this is not the first time that he's
Right.
been before court, correct?
Understood.
So he's been involved with the juvenile system since 2017. You'd agree with me, right?
I don't know the year, but I do know that it's been a while.
Okay, and so before you lived in the outskirts of Gonzales, Texas, were you living here in San
Oh,
Antonio?
yeah.
And was he living with you during
Yes.
that time? Okay, and so I guess my question to you is, back in 2017 and 2018 and 2019 and 2021, and 2022 and 2023, all of the years that he was involved in the juvenile system,
Right.
he was living with you up until 20. Is that correct?
Probably before that. I don't remember when, because I got in a major car accident and I had to get surgery for that, and then everything came back.
Okay.
Yeah.
And so he was much younger than
Right,
you, and he was still picking up charges under your supervision. Is that
Right.
fair to say?
I wouldn't say I was the best to the fullest like I am now. I'm a lot more mature. I've grown up a lot more since I was as a young mom too. And at the same time, he was a lot immature himself, which he he's still growing up, maturity wise, on that specific end. So, and then due to and then at the
I'm
same,
gonna ask you a question.
oh, yes, ma'am.
Thank you. And so during the time when he was involved in the juvenile system, he was also ingesting illegal substances. Were you aware of that?
no.
Okay, and he was living with you during this time?
He do some runaways. So, I mean, I would have to do those things too
Okay.
on that end to put reports.
And so I guess my question to you is what's gonna be different now than before when he was involved in the juvenile system and under your supervision, still committing crimes? But if I'm understanding you correctly, if you're saying that you're more mature now.
I'm a lot more mature. I have God on my side. That's one.
Okay.
I know I'll succeed with my son. That'll be number one. And then, 2, I have matured. I have a husband that's he stands strong, and I stand right beside him. And as a whole, we succeed with our children. And we have moved our environment from a quiet place, peace. It's a whole different ballpark from living in this city over here to over there.
Okay. And you're aware that your son was on probation for the offense of evading arrest and detention with a vehicle, which is a felony offense, and that occurred in 2024. Were you aware of that?
I don't remember the year.
But you know that he's on felony probation right now. Do you know that?
I'm not too great with the law too much, but I know he's been in trouble most of the time.
Okay. So he's on felony probation, which means that he's gone before this court and entered a plea, and this court put in place different programs for him to abide by.
Yes, ma'am.
Okay, and he has not done that. Are you aware of that?
Yes, ma'am.
Okay, because he went out and committed an aggravated robbery ×2. You're aware, right?
Not, well, now I know that it's been 2 aggravated robberies. Yes,
Okay.
ma'am.
Okay, and so my question to you is, do you think that it's fair, or do you think that it's justice for somebody who's already on felony probation that has shown this court that they have no intention of complying with its rules? Do you think that it's fair for the court to give us probation for a second?
I mean, that's what the judge, I mean, I can't give that answer because, I mean, really, because I'm not the judge to say so, but I can say I'm there for my son.
Okay, that's fair. Thank you. You pass away.
No further questions, Judge.
Thank you so much
ma'am.
for giving me some insight into your son.
Yes, ma'am.
All right, call your next witness.
We would call Mr. McGaha.
Good morning. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so I can hear and the court reporter can hear. If you'll state your name for the record.
Steven McGaha.
All right, defense, you may proceed.
Mr. McGaha, how are you related to Adrian Isaac Hernandez?
I'm his stepdad, but I've been in his life since he was around 2.
Okay. And just to cut to the chase, Mr. McGaha, you know that we are here because he has picked up some felony offenses and he has a motion to revoke his felony probation, correct?
Yes, ma'am.
Okay. So the question before the court is, what is going to be different this time if the court were to give him probation and put him on deferred adjudication? What can you assure this court that's going to be different this time to keep him out of trouble?
Well, he's coming back home.
Okay.
And I run a very, very strong household, and he has completed probation when he was staying with us too. And when he did do that, he was living with us.
Okay. And so you're talking about some of the priors that he's had.
Yes, ma'am.
Okay. And the court has a whole list of those, and a number of those were dismissed or rejected, correct?
Yes, ma'am.
And did he complete a couple of deferred adjudication probations under your watch?
Yes, ma'am.
Okay. And are you willing to do whatever it takes to keep him on the straight and narrow should the court grant him one more opportunity to try and behave on one of her probations?
Yes, ma'am.
Okay. Is there anything that you would like to tell the court that you know is going to be different this time to guarantee or for the court that he's going to be able to be successful?
I mean, he has been successful with me because I do see him, because that is my son. So he does listen to me a lot. And like I said before, when he was staying with us and with me, he did. He had a couple of little hiccups, but he was very, very successful when he was at home. So if he does come out, then he'll be coming home. Because I run a very, very tight ship, especially with all of my kids.
What kind of work do you do, Mr. McGaha?
I am a farmhand.
Okay. And would you be able to get Adrian some work?
Yes, ma'am, I would.
And would you be able to make sure that he makes all of his appointments and that he gets back on track educational?
Yes, ma'am. And then on top of that, I'm getting my wife her own vehicle upcoming soon. So she'll be having that. And then I'll be having my truck. So, and then I'll have my work truck too.
Okay. Is there anything else you want to tell the court?
My son, when he is home, he is very, very successful, especially when I am there. I am very, very stern with him. You can even ask him. He listens to me a lot more because I guess I just have that dad figure for him, that father figure.
Mm-hmm.
And I really do want my son home. If he comes home, I guarantee he'll more 90%, almost 100% that he will be successful.
We'll pass witness.
All right. State?
Yes, sir. So you've been in the defendant's life since he's 2 years old. It's about your testimony.
Yes, ma'am.
Okay. And so your wife is the individual that testified before you, correct?
Yes, ma'am.
And she testified that you all lived here in San Antonio, Texas until year 2020. Is that accurate?
Yes, ma'am.
Okay. And so then both you and her moved to the outskirts of the LA's Texas.
Yes, ma'am. And then we purchased our own property.
Okay. And that's where you're living
Yes, ma'am.
current, correct? Okay. And so I guess my question is, why was the defendant not living with you at the time that these offenses?
When he wasn't living with us
Well, why didn't he go with you in 2020?
in 2020 it was like a big old thing that just happened, and incident that happened at the house. So I had to move my family out, and then my son stayed with his grandma, if I'm not mistaken. And then he did stay with us a couple more times after that. And then when he was staying with us, he was in school. He had everything done, and everything was good. And then my son is he almost had it completed, and then when he turned 18, I do believe, that's when he fully moved to San Antonio.
Okay. So when he turned 18, then he moved out from you and his mom and returned back to you.
Yes, ma'am.
And so it's your testimony that, you know, he's been respectful in the time of living with the contract. And you described the problems that he's had as hiccups. But
Yes,
you
ma'am.
would agree with me that there's some pretty big hiccups, right?
I had some pretty big hiccups too.
Okay, that's not what I'm at. You think that it's a bit, would you describe it just as a hiccup, an aggravated robbery where he knows that his friends have guns and they're stealing property from people?
On
Is
that
that
end,
a
ma'am,
little hiccup?
I do not know. I do not know because I was not there.
Well, I'm asking you.
So,
Do you think,
on-
listen to my question, do you think that him acting along with his co-defendants, if he sees his co-defendant has a gun and they're pointing it at an innocent civilian and taking that civilian's property, do you think that is a big hiccup or a little hiccup?
I couldn't even see my son doing that in the first place.
Listen to the question.
That is the, I'm
Is
giving you
it
an answer,
the
ma'am.
facts that I've described to you, is that a big or little hiccup?
On that end, I do not know, ma'am.
Is it a big or little hiccup?
I was not with him.
The facts that I'm describing to you, if somebody pointed a
can't
gun
say
in your
that,
face
ma'am.
and took your property, would
I
that be a
cannot
big or
say
little
that.
hiccup?
I cannot say he did or did not because he was not with me.
Asked him, answer,
So,
judge, and
say-
argumentative.
Or
Excuse me. So just listen to the question and answer the question, okay? All right, you can ask your question.
Facts that I've described to you, hypothetically,
hypothetical.
if
Okay.
somebody acted along with another co-defendant and one co-defendant had a firearm and pointed it at an innocent civilian and the other person started taking that civilian's property, would you describe that as a big or little hiccup?
I would call that as a big hiccup, yes, ma'am.
We pass away.
We have nothing further.
All right, sir. Thank you for giving me some insight into your stepson. I appreciate you coming in to testify.
Yes, ma'am.
All right, thank you. Call your next witness.
We have no further witnesses.
All right.
Unless, did you want to say anything to the court or do you want to just rely on your letter?
Just want to say that
Well, here's the thing. If you want to say something to me, then I'll have to swear you in and the state will get a chance to ask you questions. I'm sorry? All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Adrian Hernandez.
All right, and before he begins talking, did you want to confer with him a little bit about whether he wants to say something to the court or not?
Yeah, if I could, just
Yes.
briefly. Want to do that? Okay. Judge, he'd rather just rely on the letter that he gave the court.
All right. Then let me call this cause number because I see that there were not pleas entered, and it's the motion to revoke. All right, the court is calling 2024 CR 007176. Mr. Hernandez, I'm going to show you what's entitled the motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Oh, yes, ma'am.
Are you the same Adrian Isaac Hernandez who was placed on community supervision in 2024 CR 007176 for the offense of evading arrest or detention with a vehicle on August 5th, 2024 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state, you may proceed.
Violation of condition number 4 in Bexar County, Texas. The defendant, Adrian Isaac Hernandez, did then and there fail to report to the supervision officer as directed for the month of May of 2025 in violation of conditions.
How do you plead to that? True or not true?
True.
We'll waive it down in there.
Any objections to the waivers?
No objections.
Did you understand by pleading through the violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement with regard to that motion?
There's revocation and defense in 6 years in prison.
All right. And defense, the court will, with regard to that, I'm assuming you want him continued.
Correct, Judge. We'd like it to run all concurrent with what his new offenses are.
All right. And then state, since you're opposed, I'll hear your argument, and then defense, I'll hear your argument for the cases that he's here to be sentenced on, as well as the motion to revoke. I think it'll flow smoother with that. All right, state.
Judge, so we are asking that you deny all of his applications and sentence him to 12 years in the prison and the aggravated robbery cases, and then 5 years in the prison on the collision case. Your Honor, I do appreciate in reviewing the PSI that this defendant did somewhat take responsibility for his actions, and he did enter into a plea, and his role was taken to account in the plea bargain. That's why he's given a top 12 of post, because he took responsibility and because he's not the person that had the fire. And the evidence that was stipulated to, he's acting with 2 co-defendants, and they were engaging in burglary of vehicles and local businesses in San Antonio over on the far west side. And basically they were going and pulling door handles and seeing what they could get into. And an uninvolved innocent bystander tells him to, hey, knock it off. And his co-defendant points a gun in that person's face and tells him to get the fuck out of here while he is receiving property from the other co-defendant. Your Honor, he was already on felony probation, and this court has given him an opportunity to rehabilitate himself and be a productive member of society. And he has failed to do that. And if the court were to grant his applications, he would fail to do it again. Based on, and then also in the collision case, he's driving recklessly, crashes into somebody, causes them an injury, and then he doesn't turn himself in for any of this. SAP has to go and get him out of his house. So he can take responsibility in that regard, but in the PSI he did, which I appreciate, but we are asking you to deny his applications and send it to him to 12 years.
All right. Judge, I think that the state has actually hit the nail on the head. He is extremely remorseful, and I think that the court can see that in the PSI, which is kind of unusual. You don't really see that level of remorse or taking responsibility for actions in my experience anyway, in these PSIs. I think this has been a tremendous wake-up call. I think that the family has rallied and is stepping up to take some responsibility to make sure that he can stay on the path. He has definitely gotten off the path. There were definitely people that were hurt as a result of his actions, and he is very sorry for that. I think that he has had a bad time in jail, and I think that this has shown him that he cannot go down this path, that he cannot be with these types of people, that he needs to live in his Smiley, Texas with a population of 500 and get his GED and go to classes and get a trade and go to work and stay on the straight and narrow. And I think he needs his dad, who appears to be a very strong father figure, to be in his life and to keep him on the straight and narrow and make him a productive citizen. And I know the court will have a number of programs and things to assist him with that. And I think that he is receptive to all of that. And so we are asking the court to grant his deferred adjudication and to run it concurrently and to keep him on probation in his evading case. And in the alternative, Judge, then we're asking for the lowest possible sentence that the court could deliver.
All right, Mr. Hernandez, I want you to know that I've heard all of the testimony. I've internalized everything that has been said. I just don't think that you're a good candidate for probation. So in cause number 2024 CR 007176, the court will revoke. The court is finding for true. The court will sentence you to 6 years in the prison, give you credit for any time served. There's to be no contact with Gustavo Perez. This is the run concurrent with 2025 CR 011020, 2025 CR 011311C, 2025 CR 011309A. Our request to the therapeutic community, and there's to be no residing with minors. Did you review the document in that case entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
You do have a limited right to appeal in that cause number based upon the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. In cause number 2025 CR 011309A, court is going to deny your motion. Court will find you guilty. There's an affirmative finding of deadly weapon. There's a $2,000 fine. Time and money will run concurrently. This is the run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C, taking consideration 2025 CR 0133, 2025 CR 011310C, and 2025 CC 009777. There's an affirmative finding of deadly weapon. Court will sentence you to 12 years in the prison. Give you credit for any time served. Restitution, if any, to Shamari Moore. There's to be no contact with Lincoln Gage Mertens, Oscar Carvajal Jr. Is there anything else with regards to sentencing under that cause number?
No, I don't believe so.
In that cause number, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011311C. The court is finding you guilty. The court will sentence you to 12 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Take in consideration 2025 CR 011310C and 2025 CC 00977. There's to be restitution, if any, to Paul Hike. Court will recommend the therapeutic community. And there's to be no contact with Lincoln Gage Mertens. And that cause number, is there anything else with regards to sentencing?
No, ma'am.
I'm sorry, there's an affirmative finding of deadly weapon.
Just the other thing is that we asked for a contact order with the other co-defendant, which is Oscar Carvajal.
All right, and no contact with Oscar Carvajal. And no residing in households with minors.
Is there a fine on that one?
No. And that cause number, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011020. Court will find you guilty. Court will sentence you to 5 years in the prison. Give you credit for any time served. There's a $2,000 fine that will be probated. This will run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Take in consideration 2025 CR 011310C, 2025 CC 009777. There's to be no contact with Lincoln Gage Mertens and Oscar Carvajal. There's to be restitution, if any, to Mia Alaman and Sandra Marin. And the court will recommend the therapeutic community, no residing in households with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. I know it's a lot of time and you're very young. When you go to prison, do not become institutionalized. Go there, keep your head down, try to get your degree. I will tell you, I've had clients before, and the best certification you can get, it may have changed, is welding. Because with welding, they get paid a lot of money. It'll be something that you'll be able to support yourself on, okay? All right, good luck to you.
Thank you, Judge. May we be excused?
I need the reset. Okay, I'm sorry, the dismissals for you.
Thank you, sir.
Is Flat Rock out there? People against Sterling, Joseph Wright, 25W84088-1A and B, and also 25F244059. Good morning, Mr. Wright. Your name? Muted. I can't hear him.
Good
Your
morning,
name?
Judge Sterling Wright.
All right, officer, your name?
Officer Porter.
Okay, I'm going to ask you to take your hat off if you would, Mr. Westmoreland. Your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Wright.
We have a charge here of disorderly person, public intox, and minor in possession from November 22nd. He was in front of me on December 11th. The case that he was in here on November 22, he didn't show up for on December 17th. And he also has an open intox. Where's he been?
Your Honor, he's currently living down on the road and he didn't have,
All right. I see. Where was he picked up at, officer?
in Flat Rock. That I'm not sure. I believe his address is in Flat Rock. So,
Right. You didn't graduate, did you, son?
No, I did not graduate from high school. No.
I can't hear you.
No, I did not graduate.
You're not in high school anymore.
No, I'm not in high school anymore.
Are you working?
Yes.
Where?
In Flat Rock, I moved furniture.
For who?
Work for a moving company.
Which one?
Wheel Deal Moving.
Will Deal Moving?
Wheel, like WILL. Wheel. Wheel Deal Moving. I
Yeah.
also work for other companies as well, though.
You know why I knew you didn't graduate?
How'd you know that?
Because when you act this irresponsible, there's no way you get through high school. No way.
Mm.
How many hours do you work per week?
Maybe around 40.
Maybe around 40. How much do you make per hour?
$20.
You make $800 a week. That's pretty good. Is that how much you
Somewhere
make per
around-
week?
Somewhere around there.
Why isn't he showing up besides the fact that he didn't have a ride, even though his parents live in Flat Rock and he works out of Flat Rock? That's just an excuse, isn't it, Mr. Wright?
Absolutely not.
Oh, it's not an excuse? Well, then we're going to make sure you got a ride to court. How's that? I'll make sure you have a ride to court. And they can take you over from the Flat Rock Police Department when I get ready to handle this, okay? And then you're going to have to post a high bond. So, you know, don't tell your lawyer things that are not true. Okay?
Yeah, I think he acknowledges, and he meant to say it's not a good excuse, but he understands. After I spoke with him, he does understand the importance of the hearing and making sure he clears all these matters.
So he's got a November 22 minor in possession. He must have a prior minor in possession, right? Yeah, that's what that says on the ticket. That's why they charged it as a misdemeanor. So you have that case. Give me 1 second, if you would, please. You've been in front of me before. I remember you. You know what? You have been, right?
Think so.
In fact, you were in front of me at the Flat Rock Police Department, sitting there just as you are now, right?
No, I don't think that was it. I think I had came in to come see.
You'd come to Flat Rock, or you came to the court?
No, I came to the courtroom to see. I was in court when I see.
You gonna grow up, or you gonna act like this your whole life?
No, I'm really ready to figure this out and make it to where I don't got these warrants and I don't have all these fines, and we can just put it on one accord to where I can just boom, boom, boom and knock everything down, and just instead of having warrants here and being, and keep going through this process.
Yeah, well, you're bringing this on yourself.
Well, I wasn't sure about a warrant. Like, I didn't know how that worked really. I wasn't knowing. You feel me?
Do you stand mute and wait for formal reading on the failure to pay, which is 25R514323?
That's correct.
It's a mute on there. We good.
You missed too many times here, son. John, you're going to have to go over there. We're going to have to do a screening as I ordered quite some time ago. So here's what I'm doing. Anything else, Mr. Westmoreland?
Not at this time, go ahead.
Well, I'll give you an early court date. I'll do that because I want to be a lot more fair with you than you have been with us. Okay?
Okay.
Is that all right with you, or?
Yes, yeah.
Keep doing this. I don't get it. You've missed court 4 or 5 times here. 1,510% on 25F244059. We're going to need a screening and assessment and probation, John, to get on to do screening on 25F244059. You have 210. I'm entering a not guilty plea on 25R514323. That'll be $100 cash. I will set that for January the 29th, and that will be at 9:15. And then on Judge Hessen's cases, you have an open intox and you have a minor in possession. 1,010% on that. No contact with prosecution witnesses, no alcohol, no marijuana, no illegal drugs. Do you understand all that? And that's on both the open intox and the MIP. Do you understand that?
Yes, Your Honor.
So that'll be on January 29th at 9:45, the pretrial on that. So you got a contempt hearing in front of me, a sentencing in front of me, and then you've got pretrials in front of Judge Hessen on the 29th, and again, that will be at 9:45. Okay? You cannot leave the state. You cannot violate a law. You must appear in court as directed. You need to get to court on time, sir. Okay? Don't be late. We understand one another?
Yes.
Thanks.
Probation need to zoom.
And we're going to give you, yes, probation needs to zoom in with him, officer. So if you'll just bear with us and we'll get you, tell him, John, tell whoever down there, I want him to have a court appointed lawyer. Preston Point versus Chanel Himes, 2600051. Mr. Newman, your appearance.
Thank you, Your Honor. Philip Newman appearing on behalf of the plaintiff.
All right. Ma'am, did you listen to and understand the rights?
I did listen to and understand the rights, Your Honor.
Do you wish to speak to a lawyer?
I do not. I just asked for I'm just asking for an extended time, if possible, Your Honor.
Okay, hang on. Do you intend to apply for funding?
Do I intend to apply for funding?
Do you intend to apply for funding like they talked about in the video?
No, not at this time.
All right. He told me before that you owe them $1,743.75. That includes the $125 late fees. I cut those down for you. $249.75 in court costs and $13.69 in past due rent. Do you agree that you owe $1,743.75?
At this time, so the breakdown, Your Honor, is 240, is the 249 included in that, you said, Your Honor? 249.75 is included in the 1743?
Yes.
And then what was the other amount? Just the rent portion?
Listen, $1,369 is the rent, $249.75 in costs, and $125 in late fees.
Yes, Your Honor.
You agree that you owe that amount?
Through just January 30th, yes, Your Honor.
When can you pay this?
I started at the VA yesterday hospital, and I will get my first check like by the 27th of February. So is there any way that I can pay half of that by the first check is on the 13th, Your Honor, and the second check is on the 27th. Can we please split that?
Remember, you're going to owe February rent then is the problem.
February rent is going to be $383 from what I understand based on the other letter I received.
Is that right, Mr. Newman?
I'm not aware of that. Let's see. Just give me 1 second to look at her. She does get a subsidy from Section 8. For January, her portion of it was $438, and the Section 8 payment was $1,012.
Can we do this in two payments, Mr. Newman? Listen to me. Listen to me a second. Hang on. Can we do this? How much can you pay by February the 9th, ma'am?
I won't have anything until my first check on the 13th.
That's what I meant, the 13th. How much can you pay on that date?
I can pay I can pay half of this, Your Honor. So if it's 1743, because February is going to be 383.
Here's what I'm going to do, Mr.
Yes,
Newman.
Your Honor.
Defendant to pay $843.75 by February the 14th. That's a Friday, right?
That's a Saturday, Your Honor.
Can you pay it on the 13th?
I will do my best. Yes. Can I pay by money order or because like I can't go into the portal and by the time I leave VA
By
in
February
Ann Arbor,
17th, you pay that. Balance by February the 28th, 27th. And she'll try to pay that, right? You're going to try to pay the February rent by that day too, right?
by the 27th, yes, Your Honor.
Okay, fair enough, Mr. Newman, and we'll do this as a consent, or do you want me to do it as a judge order? Whatever you want.
Judgment after hearing, Your Honor.
Okay, so ma'am, I'm going to give them a judgment, $1,743.75. You're to pay $843.75 by February the 17th, because the President's Day is the 16th, the court's closed, and Saturday and Sunday precede that, obviously. And the balance, you have to pay by the 27th.
Yes,
I'm not gonna make her pay the February rent at that time. Let's give her a minute to catch her breath. I know.
Thank you, Your Honor.
I'm too nice.
No, I appreciate
You're
you,
too nice, Your Honor. You're just
I know,
too
but
nice.
that's what I'm gonna do. She's gonna pay that to you anyway by that day. You're gonna do everything in your power
Yes.
to pay the February rent so you don't make me look bad, right?
No, yes, Your Honor, I am. I'm not going to make you look bad. I
Good.
started at VA
That's what
and
we're doing.
Arbor, so I will.
Thank you very much.
Thank you,
Have a
sir.
good day, everybody. Tanglewood
Your Honor,
versus
hold on.
and what?
I had requested a money judgment.
Did you have a well, she showed up. I didn't know. I'll be glad to give you a money judgment in that same thing there, okay?
All right, very
She
good.
showed up anyways. If you prayed for a money judgment, and you did, he's entitled to a money judgment too, ma'am.
What does that mean,
Okay.
Your Honor?
It means if you didn't pay and you vacated, you're still going to owe them in a money judgment.
Oh, yes,
That-
sir. That's fine. I understand. I
And one
understand that.
other thing, Your Honor, I apologize, but
That's
I'd like the
okay.
order to also say that Section 8's February payment will not be applied to her balance. In other words, because the money that's owing is all her portion of the monthly rent that's been accumulating over several
Okay,
months.
I think that's fair. So he's going to include that as well, ma'am. So that
February
doesn't
is not-
include that doesn't include the amount of Section 8 payment that's going to be made, okay?
So it's February for 383 because the amount is going to be 383 for February.
Correct.
I mean, you're stating now that that has to be included in this amount, or can I just have like the next pay, like by the middle of March or the beginning of March, by the 5th
Wait a
or
minute,
something?
slow
like that?
down, slow down, slow down,
I know.
slow down. What it means is you can't count that toward the $1,743.75. You're going to have to pay that.
Yes, I understand. I have to pay that full amount, 1743.75 by February 27th.
But you can't say, well, the Section 8 money that they're going to get applies to that 1743.75. Do you understand what I'm saying? You're going to have to pay that, ma'am.
I understand.
Okay? Do you understand what I'm saying?
I understand that I owe the 1743.75.
You have to pay that. He's saying to me, Judge, you're cutting her a break in so many words. You're giving her extra time.
There it is.
Well, we're not going to argue with you, but this money has to come from her pocket, not Section 8.
I understand. I'm acknowledging that I'm going to pay this personally, the 1743.75, Your Honor.
Then we're on the same track. Okay?
Good. Thank you very much, Your Honor.
Thank you.
No, you keep putting me on the phone being ridiculous.
I need a 5-minute recess, everybody. Sorry. Stay seated,
Thank
please.
you, Your Honor.
You're welcome.
You're gonna see what happens.
Oh.
Am I dismissed?
Mr. Bogus, please just mute your microphone for now. And
Wait,
he'll
am I
call you
dismissed?
when he's ready. Ms. Himes?
Yes, yes, ma'am.
I do believe you're done.
Okay.
I came in on half of that, so I do apologize.
Certainly. He explained it. He explained
okay.
it to me. Am I going to receive something in the mail for this?
Yes, ma'am.
Okay, certainly.
Yes, ma'am. You're
All
good to
right.
go. All right.
Okay,
Thank you. Have a good
so
day.
much. Have a great day. Thank you.
You're welcome.
Bye-bye.
All right. Let's see here.
Deerfield Estates versus Emilio Castillo, 2505285. Who is on this case?
Judge, I do believe Mr. Joseph is also on this case, and he may have stepped. Oh, it looks like he's here, but he did say he had to step out for a quick moment.
I'm back. I'm back.
Oh, he's back. Oh, there he is. All right then.
I didn't hear the name of the plaintiff on this one.
That's okay. This is Deerfield versus Castillo, 2505285.
I thought I heard that, but that is not one of mine. I'm sorry. I have South Point and I have Tanglewood as plaintiffs.
Who's here for Deerfield? Anybody here for Deerfield?
Do you know what office it is, Judge?
Mr. Levine's.
One moment. I have Mr. Winkleman here.
Okay,
Looks
bring
like
him in.
he's coming in.
Do I have Emilio Castillo here?
Yes, Your Honor.
You have to start your video, state your name.
My name is Emilio Castillo.
You have to start your video first.
Right. Give me one moment, please. Okay. My name is Emilio Castillo.
Good morning to you, sir. Mr. Winkleman, you're here for Deerfield, right? You have to start your, or unmute and tell me your name, Mr. Winkleman.
Richard Winkleman on behalf of Deerfield Estates. Our attorney, John Capitan, should be on also.
He is here, Judge. I am admitting him.
Okay. Mr. Capitan, I need you to start your video, sir. There you go. Your appearance?
John Capitan, appearing on behalf of either Deerfield Estates, Fountain West, or
It's
Grand Cola
Deerfield
Valley.
versus
Deerfield?
Castillo.
Okay.
Okay. What are we doing on this one? You spoke with a lawyer, Mr. Castillo?
I was not able to get in touch with a lawyer in this time period. I did try to reach out. I did not receive a call back, and I do not have the funds for a personal lawyer.
How much is owed here, Mr. Capitan?
Well, it's not about owing, Your Honor. This is a termination.
Oh, it's a termination. I'm sorry.
Right.
Yeah.
This is a termination. Last time we were here, Mr. Castillo, we tried to work something out. Didn't work out. He indicated he wanted 45
Yes,
days.
I
He wanted
Hang on,
45
hang on, let him, wait, whoa. Mr. Castillo, wait for him to finish, please.
Right.
Go
So-
ahead, sir.
Apologies.
Yeah, so Your Honor indicated that he should figure something else out because we're allowed a 10-day judgment the next time he appears. There's no gas or heat here. DTE shows it as a vacant house. There's 2 unregistered malnourished dogs. It's just, and when it was being posted, the process server even indicated it was the most disgusting place he's ever seen.
But this is a
So-
just cause termination. He owns the mobile home, right?
Yeah, he does.
So what is the just cause?
Well, just causes that he's not keeping his manufactured home in compliance with the community rules and the lease, and that it is.
What section are you proceeding?
We're proceeding on, let me get to the section, Your Honor. On the lease, it is.
Maintaining the physical condition. Failure by the
Right.
tenant to comply with the lease or agreement of the park or with the rule or regulation of the mobile home park adopted by the lease or agreement, which rule or reg is reasonably related to maintaining the physical condition or appearance of the mobile home park or the mobile homes on site. True?
True, Your Honor. Also 2E of the lease where it indicates tenant further agrees.
Why aren't you taking care of that, Mr. Castillo?
I've actually been between 3 different jobs at the moment. I'm a single provider with, attempted to make the money because basically 2 jobs are a little bit slow. So I'm going back and forth. And then right now at the time I was on midnights. So when I was home, it was late. I wasn't able to cut the grass and stuff like that because I was actually not home in the daytime.
Well, you're not, nobody's cutting
But
grass
now-
in January. I mean, if you are, tell me where
Right,
you are. I want to
exactly.
join you.
That was the thing, that given due time, I'm now back to a steady, just single job. I work daytimes and
Mr.
given
Castillo,
provided time,
Mr. Castillo,
I can actually,
Mr.
Yes, sir.
Castillo, listen to me. They sent you this notice back on October 30. Okay?
Yes, sir.
They advised you of what needed to be done. They sent you a notice to quit. This is now the latter part of January. So no matter how you've cut it, you've had 31, 62, 89 days to take care of this. Why aren't you taking care of it?
I personally didn't have all the time, and now that I do, and I am about to receive the funds, can have that all taken care of.
Mr. Castillo, you're not moving quick enough. Now, I don't know how much equity you have in this mobile home, but I can tell you that you're going to lose all the equity you have, whether it's $1 or $20,000 or whatever it's worth. It doesn't sound like you were very diligent about getting a hold of the lawyer. You called the lawyer's office once, according to you. That's what I heard anyway, reading between the lines, and the lawyer never called you back. How's he supposed to do all of this, counsel, right now in the middle of the winter, though?
That was kind of my.
Well, I know, but you waited and waited and waited.
Right.
They didn't give you first notice of this October 30, Mr. Castillo.
No, I understand that.
You
but,
knew that. You know that. Yeah, but you know what? I mean, I want to try to help you, but you almost made it impossible. You follow?
I understand, Your Honor. As I said, some of the things, they were beyond my means at the point in time. I didn't have the funds to rent a power washer, things of that nature, get new windows, or buy new siding, or
Now you
install a
have
new
the
deck.
ability to do all that, is what you're telling me.
Yes, as of this tax season, I do have the ability. I have $15,000 coming in, so I
Nice.
actually have the ability to get all of that taken
Mr.
care of.
Winkleman shaking his head.
Yeah, and the reason, Your Honor, is that this is like I said, this is going on even before October. Obviously the 30-day notice was October 30th. However, there were three, and I can show Your Honor, there were three violation notices, and this is during the period of the summertime.
When was the first?
The first one, I'm scrolling to it, Your Honor.
You want to tell me before he does, Mr. Castillo? It might soften the blow a little bit, especially if you're honest with me.
Yes, no, it's exactly as I said. I was in between multiple jobs.
No, I didn't ask you about that. I heard you.
Oh,
when is the
okay.
first notice that you received?
Oh, I do believe that it was in the summertime due to grass.
All right. So when in the summertime? The summertime covers a wide range of. It's right. I mean, some people think the summer's in May. Some people think it starts whatever. Tell me what month they sent you that notice.
I believe it would be closer to May, early May, end of May.
So May, June, July, August, September, October, November, December, you did nothing.
No, I did cut the grass several times. I just received several of the grass notices when they got too long.
How much do you have equity in that mobile home?
I'm sorry?
Do you have equity in that mobile home, or are you underwater in the mobile home? What?
I wouldn't say I have like considerable equity. Like
I didn't ask you that. Do you have equity in it?
Yes.
How much, you think?
I'd say roughly 15,000.
Oh, geez. You're going to lose all that. You kidding?
In Your Honor, DTE shows the house is vacant, so no gas, no heat. So I don't know
you
what's
living
going
there?
on.
Well, but that's his worry, right? Not yours.
True, but
you guys don't want anything to happen. But are you at the mobile home right now?
I'm in between the mobile home.
What in the world does that mean? You know what? Just be straight with me. Are you at that mobile home now?
I'm currently at the mobile home, yes.
Let me see. You move your camera around so they can tell me whether or not you're at that mobile home. Show me something outside that they can identify.
This is my neighbor's house.
Is that true, Mr. Winkleman? Is that his?
It looks like it, Your Honor.
How long have you been at the mobile home? Did you stay there last night?
Yes, I did.
The night before?
I've been here all week. I work down the street.
You don't have heat on?
No, I have heat, yes.
Not according to DTE, Your Honor.
Show me your thermostat.
Oh, I have solar power in here right now at the moment.
Solar power.
Yes, I have EcoFlows.
Because you didn't pay your DTE bill, did you?
No, not mine. I don't have mine. I haven't had one in a while.
Your Honor, it's part of our, I'm sorry to interrupt. It's part of our rules and regulations at the community that they maintain all utilities at the home at all times. This is not the first go around with Mr. Castillo. We have been back and forth with him on multiple 30-day terminations over the past few years. His rent payment history with us is atrocious. The condition of his site is atrocious. Plus, we have concerns, and these are more personal concerns than business. But if he has children in that home and there's no heat and electric, I mean, normally you would be in a situation where Department of Human Services would be called.
Do you have kids in that home with you, Mr. Castillo?
I do not. They stay with my mother.
Where do you work at?
I work at a place called Pace Industries. It's down the street. It's a truck and trailer repair shop.
How many hours do you work per week?
40.
How much do you get per hour?
$24.95.
So you're not doing bad. I mean, that's $1,000 a week on my math. If you're working
The
40
house.
hours
That's
at
why I'm buying.
$24.95, that is should be about $987.50 or thereabouts per week. That's not bad. So you should be able to pay utilities, get these things cleaned up. It's tougher, Mr. Winkleman, when I've got a just
understand.
caught Mr. Castillo. I'm trying to talk right now. It's tougher when I got a guy with 15,000 in equity. I hate to throw him out right now.
He doesn't own the home free and clear, Your Honor. There's a bank loan on that home.
I know. He said he had 15,000 in equity, which means that you have the value of the mobile home less the amount owed. You're telling me if you sold that right now to an average prospective purchaser at fair market value, you'd walk out with $15,000 in cash in your pocket, right?
Between 12 and 15, yes.
Now we're down to 12 to 15. Before you said 15. So think again. I don't want guessing. This is not Wheel of Fortune or Jeopardy or anything else. How much?
I'd say fairly 12, to be completely honest, 12 with the condition of the decks.
I don't think you need to preface it with being completely honest. You're in a courtroom, so I expect you to be completely honest. I don't get it. Why don't you go out and get a second and third job? You know,
I have a second job.
from
My
my
second
perspective-
job,
Well, then you're making all kinds of money. If you're making 50 in your first job, where do you work in your second job, and how much do you make in that job?
I make $16 an hour. I work as a cook at a bar called Marlowe's on Telegraph and West Road.
Okay. We get cases out of there, so I know where Marlowe's is. How many hours do you work at Marlowe's?
I work Friday, Saturday, and Sunday. I'd say between 25 and 30 hours, depending on the
So
busyness
you
of
are
the day.
making, listen, if you're making 16 bucks an hour and you're only working, let's say 20 hours, that's 320 on top of the 1,000. That's $1,320. What are you doing with your money?
Currently, that's why everyone is living with my mother, and that's what I'm doing is actually paying for everything over there as well as everything over here because my children are over there while I'm trying to keep this place up at the same time. So I'm providing for both places at the same time.
You're making it hard for me to help you. You know that?
I understand. But if given the time, I can have absolutely all issues taken care of by the end of March, including the DTE.
Your Honor, can I chime in again, please?
Well, let's let your lawyer talk first.
Okay.
Yeah, Your Honor, as I could say, this has been going on since the summer. Again, last time he indicated he only needed 45 days to vacate. We're here again at the second hearing. We're asking for the court to issue and
I know you are. Here's what I'm
Yeah.
doing. I'm not going to do that, guys. I'm coming out and looking at the place. I'm coming out and looking at it. And we're going to set a time in about 5 weeks. You got 5 weeks, guys. Don't, if you want to talk about me when I'm done here, it's okay. You can get on the phone and say I'm the worst judge in the county if you want to, but please don't let me see guys shaking their head. Please. I'll get upset with that. Okay. I'm not going to put up with that. So give me a date in 5 weeks and I'm coming out there and these guys are going to be entitled to meet me out there. I'm going to tell them the time and I am going to be gone. Let's see. I think I go the 14th. Okay, so what is my last docket day? My last docket day, Linda, I need.
For February, Your Honor?
Can't remember what days I'm going on vacation. Call over.
I don't see anything in February.
No, it's in March.
Oh, right. March 5th through the 12th. Then
Let's
you
set
have,
this.
well, you have a docket day on the 24th, but you have a trial that day.
24th of what?
March.
Well, I know, but I'm going the 5th. I'm going to do this before. You're going to
Okay.
have it done before then, right, Mr. Castillo?
What date, sir?
What day am I coming back again?
You come back on the 12th.
All right. What's the first bit, I don't need, we don't need to do this on a civil day. I'm going to do it
Okay.
the first time I can get out there after the 12th of March. And we're going to go there. We're going to set the case for 9, and I'm meeting these guys there at 8:15.
Do you want to do then March 16th? That's a Monday.
Absolutely. At 9:00. Now, I want you to tell Lisa and Heather I will not be here until 9:00 that morning, so don't set anything because I'm meeting there. And you're going to put this in my docket, okay, Sadie, in my calendar. My court officer are going to be out there March the 16th at 8:15 in the morning. Now, I expect all this stuff done, Mr. Castillo. I'm cutting you a break. Do not force my hand because I will issue a writ and you're going to be out of there in 10 days and you're going to lose 12, 15 grand or whatever it is. You got me?
Yes, Your Honor. Absolutely.
You got me?
Absolutely.
Guys, I apologize to you, Mr. Winkleman and Mr. Capitan, but that's what I'm going to do. Good luck. Thank you. Deerfield
brother.
versus Randy's. Make sure you do everything, Mr. Castillo. I'm not going to give you another chance. Granite Televalley versus Ronald Allen Bodges, 2600001. Mr. Bodges, your appearance. Mr. Bodges, your appearance. I need you to unmute and tell me your name, sir. You're not unmuted. I can't read lips. Unmute, bottom left-hand corner of your screen. I'll go on to another case. Granite Televalley versus Joshua Summers, 2600046.
John Capitan appearing on behalf of the plaintiff.
Mr. Summers, your name?
Joshua Summers.
Did you listen to and understand the rights on the video?
Yes, I did.
Do you wish to speak to a lawyer?
Yes, please.
You wish to speak to a lawyer?
Yes, please.
I'll give you a week. Adjourn it to February what?
February.
Linda, what do you? I need a 1 week adjournment on this Summers.
That would be February 2nd, Judge.
Who am I hearing right now, Mr.
Jen Miklos. You're hearing Jen.
Yeah, I know, but I'm hearing other people too. February 2nd, you said?
Yes.
Yeah.
And let's see. Let's do who is this for? Let's do 10 o'clock.
10 a.m.
Yep.
10 a.m. February 2nd at 10 a.m. Do you intend to apply for funding, Mr. Summers?
Yes.
You do?
I'm sorry, I couldn't hear you. You said.
Well, then why are you saying yes if you didn't hear me? Do you intend to, listen to my question.
Yeah.
Do you intend to apply for funding?
Yes, I would like to.
Did you listen to the rights?
Yes.
Do you understand what I mean when I say that?
Yeah.
I get the feeling you don't. Do you certainly understand what I'm talking about?
No, like funding through the state?
Yeah, through all those departments, all those agencies.
I would like to, yes.
All right, good enough. We're going to apply. He's going to apply for funding. I need another week out. We need proof that you've applied for funding.
Okay.
Within 7 days.
Okay.
And I'm going to adjourn it out 2 weeks, and they're going to chat with you and give you the number of the law firm to call. It's Lakewood or Lakeshore. And what is the date now? February 9th?
Fuck you! Fuck you, motherfucker!
Ooh.
Who said that?
I think that's Mr. Bogus, and I think he
Yeah, it's
found the
Mr.
unmute button.
Bogus. You motherfuckers gonna cut me off?
Oh.
Who do you think you are? Who do you think you are?
I can't see you.
Who do you think you are?
I'm nobody.
Who do you think you are?
I'm nobody.
I want to know what kind of a punk would do that.
Bro, I can't see you. I was just on
You are not going to swear on
video
Zoom.
with you. I
You are
was just
not
on
going to.
video
I'll
with
tell you
you. I
what,
can't
Mr.
find you.
Bodges, you're going to come up here now. You're going to come up here in person. You talk to me like that, you'll be in lockup for 30 days. You want to act like a punk? I'm going to treat you like one. You get up to the courthouse now. You got it, Mr. Bodges, Mr. Tough Guy? You must have fought Muhammad Ali and beat him, huh, back in the day? Come on up. You're coming up, Mr. Bodges. You want to talk to me like that? You're going to end up in lockup, tough guy. You got it?
No, sir. No, sir.
Good.
Good.
He's coming up here. He doesn't come up, I'm defaulting him. I'm giving you half an hour to get here. Shut him up. Half hour to get here, Bodges. Now, Mr. Summers, where are you at? Everybody's a tough guy.
Judge,
Huh?
Mr. Summers, I went ahead and put him into a separate breakout room so that I could give him the number for Lakeshore.
Okay. I need to give him a date, though. So why don't you bring him back?
Okay.
Because I didn't give him a date. We don't want to do February 2nd. We're going to do a week later.
Okay, Judge. He should be hopefully coming back out right now. Here he is.
Okay. We're going to give you another date. You're entitled to a 2-week adjournment, and you are going to have to provide us within 1 week proof that you've made application for funding. I would suggest you come up to the courthouse.
9:30.
They'll give you the attorney's name or office number, and they'll give you any and all the other information you might need to apply for funding. If you can't come up here, they'll chat with you, and they will tell you what law office to call, the phone number, and give you that information. Okay?
Okay.
All right. Let's go to February what here, Jennifer? We're not doing February 2nd anymore.
It's going to be February 9th, Judge.
At 10 still?
Let's do 9:30, please.
9:30. 9:30 on that date, okay? On
Okay.
February 9. February 9, okay?
Okay.
Thank you. We're going to do this one with you, Mr. That's Granite Televalley versus Bodges, right?
Yep.
Come on up here. Ronald Bodges, 2600001. Got Mr. Capitan, your appearance.
Yeah, John Capitan appearing on behalf of the plaintiff.
Your name?
Ronald Allen Bodges.
Do you have anything you want to say? Okay, so let me give you a little bit of advice. You can take it or leave it. When I extend the courtesy of allowing somebody to appear by Zoom, when I allow somebody the courtesy of appearing by Zoom, I expect them to have the common sense to know that they're in a court. That's what I expect. We're not a bar. If we were to talk like we were in a strip club, I'd bring the recorder to the strip club and my court officer to the strip club.
Stay home. I don't go.
Watch your mouth. Do not interrupt me.
Sir.
You use the F-bombs on Zoom ever again with me. I don't care if you're at your house. I don't care if you're in Mackinac Island. I don't care if you're in Tuscaloosa, Alabama. I don't care if you're in Russia. I don't care if you're in Venezuela. You will come over here and you will serve 30 days. Do you fully and completely understand what I am telling you? I didn't ask you if you heard me. I asked you if you fully and completely understand me.
I do not.
Well, then you have a seat right over there and maybe I'll put you in the lockup. Hang on. You want to be a smart guy with me? I'll put you in the lockup for a few days. You can think about whether or not you understood. Stop it. You do not. You said you do not understand. So I'm going to make you understand, Mr. Bodges. You want to be a tough guy punk with me? You're messing with the wrong guy, okay? I'll just tell you that. I'm not that nice. I'll treat you with respect, but you're not going to treat this system like it's your lapdog. You got what I'm saying to you? Yes, sir. Now, I'm going to ask you one more time. Do you fully and completely understand what I have said here today? If you tell me no, it's okay. We'll just put you in lockup for a while. Maybe you'll be able to. Huh? You sure? I didn't hear you.
Yes, sir.
You ever pull that nonsense with me, Mr. Bodges? You want to be disrespectful with everybody else? That's your business. You start being disrespectful with courts in this building, which is one of the finest in the state, fully and completely understand one another.
I do. We do.
Your appearance, counsel.
John Capitan, appearing on behalf of the plaintiff.
Sorry about that.
All right,
I
Your
just
Honor.
felt like Mr. Bodges and I had to have a little conversation.
No, I totally understand, Your Honor.
Did you listen to and understand the rights that were on the video?
Yes, I do.
Okay. Did you, do you wish to speak to a lawyer?
I can have it.
I can adjourn this for a week for you to speak to a lawyer.
Please.
I want you to understand this is a complaint to recover possession. It's a termination of tenancy. You're going to have to explain everything to the lawyer. But I want you to understand that this is, I'll adjourn it 1 week. They're going to give you the phone number to contact the lawyer, and I still want you in here personally since you forfeited the right to appear by Zoom in the face of your vulgar language. Do you understand that?
Yes, sir.
You've been drinking today?
No, sir.
If I give you a PBT, you going to pass it?
Absolutely.
Because if you get back in that car and you drink, if you've been drinking, well, then you have been drinking, haven't you?
No, sir.
Well, then why'd you Uber?
Because I don't have a license. I have to Uber everywhere.
Well, that's good. I'll adjourn this 1 week. February what again? The 2nd?
9 o'clock, Judge.
At 9 o'clock. You go down the hall. They will give you the phone number. They will give you the phone number to speak with a lawyer. Okay? And then you'll come back in a week. But I'm not going to put up here with your nonsense. You understand me, Mr. Bodges?
Yeah. I'm downtown and fighting a case.
I don't care about downtown. You're not yelling on here F-bombs. What do you think this is? Get out of here before I lock you up. Go ahead and laugh all you want. I'm telling you, you do it again, you're going to end up in there for 30 days. I promise you.
Randy Cooper here on behalf of plaintiffs.
Good morning.
Your Honor, Travis Gagnon on behalf of defendants, Eric and Paul Cassidy.
All right, very good. All right, this is actually the time and date for your motion, I do believe, isn't it? The motion for this court to assume jurisdiction.
Yes, Your Honor.
All right, yes, go ahead.
Yes, Your Honor. On behalf of plaintiffs, we are requesting that the court accept or ask for concurrent jurisdiction. So from the circuit court, so the matter can be kept here in district court, where Your Honor has had a lengthy experience and history with the case, and we feel it would be just most efficient from a judicial perspective and from the party's perspective if the case could continue in front of Your Honor. In the alternative, we would request if the court is unwilling or unable to get concurrent jurisdiction, that the case be permitted to be moved to circuit court because the claims exceed the court's district jurisdictional limits. The defendants filed a response, a very brief response indicating that they did not oppose the relief, the primary relief requested or the alternative requested.
Thank you, Your Honor. I'll start by saying I appreciate the extra time that you gave us at the last hearing for me to catch up on the case and to file our response, put it on the record. Ms. Cooper is right. We have filed a response on behalf of the Cassidys. There is no opposition to either requesting concurrent jurisdiction from the circuit court or asking that it be removed at the circuit court for the monetary claims here. The only thing that I will say, again, and I think that's everyone is in agreement. The only thing that I will say is that I think that request needs to be made of the circuit court in the last 2 weeks. We are now on our 5th docket. So a new case has been filed in circuit court. It is now before Judge Tracy Vandenberg. It is filed on behalf of Cambridge Family Holdings only. The Jeromes are not plaintiffs or any party to the case. It is named again as Eric and Paula Cassidy. It is the same claims that are before Your Honor. And I know that because there's still a 14A1 district court case caption on the complaint.
So
We
back up a
need
second.
finality is what I'm saying. And so
Hold on. A new case got filed in circuit court?
yes.
I
missed out.
Yeah, I figured as much. All right, so that means that there are 2 cases pending in circuit now?
There are now 2 pending cases in circuit court.
The 2 in circuit court, are they before different judges?
They're both before Judge Vandenberg.
Okay, all right. So let me shortcut this a moment. Because one of the things is, and it used to be, and I'll just try to be as nice about it as I can. It used to be, for the sake of judicial efficiency, that those judges in the district court would be able to take cases, they get the assignment, it would just be pretty much rudimentary. What has come up in a couple of cases, so some do go through, some don't, is that there isn't a concurrent plan that would allow this court to take it, which is very odd. And because normally what would happen is I would just be appointed a circuit court judge and just deal with it. Personally, and as a judge, I don't have any objection to doing that. I don't think that process would work. I don't think that it's beneficial. And again, this is my personal feelings. I don't think that it's beneficial for the parties. I think counsel is right. I've been dealing with this case, I don't know how long. And I don't know how far Judge Vandenberg has gotten into it. I mean, I'm sure she'll catch herself up and do what is necessary. But it seems to me that you're going to be spinning your wheels there, trying to just catch up. I will say also, now knowing what you've told me about another case being filed, that doesn't surprise me. And Miss Tope is not here, is she?
She's not here.
It gonna be, I'm too old to worry about getting myself in trouble.
You're only 29.
Right. Okay, so maybe I am. There is another case not involving these parties, which had the same issues regarding Miss Tope's involvement. That I basically had to, I don't want to say force her, but she had to withdraw from that case. So I would suspect that Miss Tope did that because Miss Tope may not want to see me. Just be blunt about that, but that's okay. I get that. So that indeed does not surprise me at all. So I think in ruling on this motion, I think what's going to have to happen is it's going to have to be moved up to Judge Vandenberg for her to hear this case. If Judge Vandenberg in some way wants to send it back, and I want to make this very clear, I have no objection whatsoever to the issues coming back before me. None whatsoever on it. And so, and if she believes that we could go through a process of maintaining, let this court rule on it, her certifying this court's rulings, however she may see that type of procedure, if it could work, I don't have a problem. And so that's how I'm going to rule on this, that the case needs to be removed. She does have the power to send it back to me if she believes that that's the case. Sorry. I'm going to miss you guys. All right. Okay. Anything else before that removal becomes final that I need to deal with?
No, I think.
Your Honor, can we have 1 minute?
Sure. Sure. Absolutely. I'm sure I'm probably surprising you. And I apologize, folks. And can I just say one other thing? And I don't know what you guys are talking about, but if, and not only if Judge Vandenberg wants to send it back, but if there are portions of this that, because of where we are in this case, that Judge Vandenberg does not have a problem with this court ruling and wants to do that, I am not going to have any objection to that, because I think it's a waste of time and effort from that the parties have put into the case to have to do it this way. So, go ahead.
Your Honor, we just have a quick sidebar. We would like to request, we know where you are coming down on this. We would like to request you to put another conference maybe on the calendar in 2 weeks and hold this under advisement before making a ruling, to allow the parties who are here in the courtroom today to further discuss before this gets removed from your courtroom.
Okay. You agree with
that?
Yes, Your Honor. We would request that the decision be held in abeyance for now, and then we reconvene in two weeks.
Do I have 2 weeks?
You have the 10th and the 17th.
10th or the 17th, whichever. You know what? Is that February 17th?
Yes.
You're not going to want to be here that day.
Why?
I think there's going to be a lot of press around here.
On the 10th, you said?
On the 17th.
Yeah, I'm pretty sad.
Okay. So I will adjourn this for a decision to February 10th, 2026, 9 a.m.
I'm sorry, what time?
9 a.m.
Thank you, Your Honor.
All right. Thank you, folks. And again, my apologies on all of that. And could counsel approach briefly? We don't have either defendant out here, but the court does call the case of Jamal Jones and Omar Smith, people versus.
Peter Childers appearing on behalf of the people, Your Honor.
Dr. Waters is prosecuting attorney on behalf of the people.
Randall Upshaw, my apologies for my mistake on behalf of Mr. Jones.
And Judge Colin Daniels on behalf of Mr. Omar Smith. I am stating it for the attorney of record, Neil Rockine, in this matter.
I will bring the defendants in. Somebody's going to need to explain to me why I'm almost 2 hours after start time on this case.
I can start. I just wanted to say, Judge, you know, I received a phone call that the parties, attorney and Mr. Rockine, I informed them, well, I'm ready, but if the judge doesn't want to do 2 bifurcated cases and the attorney is not prepared because he didn't have discovery, I'm not going to oppose it. But if it's so if you got my permission to sign the order, and that's what my order. So I thought when I gave permission to sign the order, because and I'm not throwing any stones at Mr. Rockine, he's a brand new attorney, and I've just called myself giving respect to the parties. And said, I leave it to the powers that be. Then I went to, had a hearing up in, St. Joseph this morning, and I found out on the way back, and I apologize because there's a blizzard up that way. But I didn't know until I got halfway in the middle that you didn't sign the order when someone called me, because I thought it was adjourned.
Anybody else?
Yeah, Judge, so I guess I can weigh in on that as well. So we just got retained. Our office was just brought in 10 days ago. We just finished downloading all the discovery actually yesterday. I had talked to the prosecutor's office to let them know that we were going to be requesting for. I think we actually had emails back and forth with your staff that was, and we were told that it was going to have to go on the record, any kind of adjournment request. So I was.
Well, I think it was made clear I wasn't necessarily adjourning. I mean, and also the bigger problem, and I don't even know how the email chain started, but I don't even think Mr. Upshaw was on that initial email chain.
No, I don't think he was. I think that's accurate, Judge.
Go ahead. I'm sorry.
No, that's okay, Judge. So, I mean, I think just given the short amount of time, you know, obviously our plan was to come in here and ask the court for an adjournment. We weren't presuming one, but given the short amount of time, we were hopeful that the court would be understanding with it. In addition, just so the court's aware, Mr. Arraigned, who was the one that filed his appearance and is going to be handling the matter, has been unfortunately stuck in a much longer murder trial than he had anticipated. So he's been in a murder trial in Oakland County in front of Judge Cunningham since January 12th. We did not anticipate it going this long. I just found out a half an hour before the court came out that the jury had come back with a verdict. So we now have a verdict in that case, but Mr. Arraigned is still stuck over in Oakland County. So I guess that's kind of the situation.
The people.
And Your Honor, for Mr. Overwater and I were in front of Judge Conlon last Wednesday when Joe Hall from Mike Vincent's office let us know that they had been retained out with respect to Mr. Smith. I called Mr. Daniels that afternoon once I heard that it was Mr. Arraigned's office and explained to him, because Mr. Daniels obviously said our position was asked for the examination. Are you agreeing to that? And if memory serves me right, my conversation, something effective, I'm not going to object because I understand the position you're in. However, we had two defendants and the people's position, strong preference to hold one examination, not two. So I'm not in a position to, offer a stipulation, not saying the court wouldn't accept it, but that was the people's position. And then Mr. Overwater spoke with Mr. Upshaw, I believe it was either Thursday or Friday of last week, to let Mr. Upshaw know that what the status of the co-defendant was and to get what input he would have regarding that adjournment. But the people have maintained that there is a possibility that this court may decide that while one defendant's exam may be adjourned, the other defendant is sitting in custody and that exam may proceed. So we've been in continuous discussion with Detective McDonough about witness availability in the event that an examination is held this afternoon.
And I also made a stipulation regarding one witness, this female witness who made a brief statement. I can't think of her name, the counsel knows her name. And I informed him, hey, I can go. And if you can't find the witness that I want, I'll just stipulate. We made a stipulation for exam purposes that we read the tape if we go forward, the 5-minute video of her statement of what she saw. Just like I said, I'm just here. I'm doing whatever the court, whatever it wants to do. I'm ready either way.
And so as I sit here right now, if I said we're going, you're not prepared to go.
No, Judge.
If I didn't agree, and unless you believe that there was something that came from my office that said this was to be adjourned, I don't know why I don't have the attorney of record or the one that's going to handle it here now.
The only thing I can fall back on, Judge, is what I kind of already explained to the court. I don't have a better explanation than that, Judge.
So the court set aside time and your office just thought we were kidding in terms of the time.
No, Judge.
I've got these two people in custody. And then somehow or another, people are led to believe, and I've known Mr. Upshaw for a while, and I think if something had to be intimated to him that there was an adjournment, otherwise he would have been here. There's not a doubt in my mind about that. And I have to say that must have come from the people in some way, because he would have been here. And now I'm sitting here today, 2 hours after when I was supposed to start, and can't do anything. How many witnesses do you have here?
Right now, the only witness we have here is Detective McDonald.
Where are the other witnesses?
They're on standby or.
Yeah.
Meanwhile, these two individuals are in custody on murder charges, and this is the best we can do, folks. Really? How long is it going to take you or your office to be ready to go? And I'm not giving you much time.
I understand, Judge. I mean, I will preface this with, I don't know how much discovery there is. I know that it took my office 3 days to download it all, to go through it all and get it all downloaded.
Counsel, then go out, call the attorney that's going to handle this case, find out how much time he needs, because I'm going to set this, and then everybody's going to be here. Everybody's going to be ready to go. These two gentlemen are going to have their exam. Am I clear?
Clear, Judge.
Court is staying in recess. You let us know when you.
All rise. Commission is now back in session. The honorable judge.
You may be seated. Let me just say I was a bit remiss in calling these cases. We're going to need to defend it. For the attorney. Bit remiss in not acknowledging that seated with me on the bench is my newest colleague, or our newest colleague here in Washington County, Judge Garwood out of the 15th District Court. So he's also presiding with me today. Court does call the cases of the people of the state of Michigan versus Omar Ernest Smith and the people of the state of Michigan versus Jamal O'Neill Jones.
On behalf of people.
Hearing on behalf of the people.
Colin Daniels on behalf of Mr. Smith.
And Randall Upshaw on behalf of Mr. Jones.
And the defendants at this time are present. I've indicated to counsel that my staff had provided dates. I was not going out as long as some counsel wish for the court to go. I will go out 2 weeks. These gentlemen are entitled to have their preliminary examination timely when things are ready. It was set and I set aside the time. I will adjourn. My understanding is the parties have selected the dates that were available for the court. February 6, 2026 at 1 p.m.
Excuse me, I was told noon.
Yeah, I was told noon too.
I did say noon.
Okay, then we'll set it at noon. The way we're going, the way you guys won't show up till 1 anyway. No, I'm kidding. All right. Is that correct?
That's fine.
Thank you. All right.
That's correct, Judge.
All right. Bond will continue as denied both of these cases. Thank you.
Thank you. Thank you, Judge.
All right, so let's go on the record in the matter of the Andrela Hager, 22991. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, on behalf of Ms. Hager. I'm in the wrong thing.
No, sir, you're right where you're supposed to be. It's just gonna be a little bit before your hearing. Okay, and so ma'am, your name for the record, please.
Angela Hager.
Okay, thank you. Today is the date scheduled for probation violation. Ms. Hager is on probation for attempt retail fraud. And it's alleged that she failed to appear for probation visits on November 9th of 2022 and November 29th of 2022. And, counsel?
Yes, Your Honor, I had a review of the documentation that was sent to me. It indicates, yes, she missed these 2 dates. I gave her the notion of what she was able to do regarding a hearing to contest whether or not she was there on those dates and time. That will not be necessary. She'll admit that she failed to appear at those probation visits, Your Honor.
Okay. And so ma'am, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth? Okay, I need you to speak up a little bit more loudly, please.
Yeah.
Perfect, thank you. I'm recording on my device here, so that's okay. And so ma'am, you did hear, you may lower your hand. You did hear the allegations that were stated on the record, correct?
Yes.
As to the allegations, ma'am, how do you plead?
Mm-hmm.
And you've gone over your advice of rights for probation violation purposes, correct?
Yeah.
And you understand all of those rights?
Yes. He was saying like, pay the, balance over $1,000 and then, continue the probation. Is that correct?
Well, no, first I want you to understand that your various rights that you have for probation violation hearing.
Yes.
And that by entering into a plea that you're going to be waiving some of those rights.
Yes.
And you've gone over those rights with your attorney.
Yes.
Okay. You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
And you understand the recommendation in this matter is for probation to be revoked, under advisement status to be revoked, probation violation fee, and it says 15 days jail. Do you understand that?
Yes.
And as well as paying the balance in full. And knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? Any immigration issues?
No, Your Honor.
All right, counsel, if you can please review your client.
Yes, I'd like to direct your attention to the dates of November 9th, 2022, and the dates of November 29th, 2022. Do you stipulate that you did not appear to probation visits as previously ordered by the court?
Correct.
You need to speak up, please.
Correct.
Okay.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate, and the court will accept your plea to the probation violation, indicate technical violations 1 and 2 will enter based upon your plea, and counsel as to the recommendation.
Your Honor, my client indicated that she was unaware for whatever reason that this was still an outstanding issue, but she is now gainfully employed. She works at UPS. She's a package handler. She lives in Detroit with her mother. She's not on probation or parole. She's 27 years old. I know it's a little bit older of a case, but I'd ask that she be given an opportunity for a review to see if she can get this balance outstanding and potentially find herself in a more advantageous position. Obviously, with the balance, I think that sending her to jail at this time would potentially lengthen the amount of time that she could get this balance zeroed out. So I'd ask for a delay of any aggressive admonishment at this time, Your Honor.
So, ma'am, why didn't you appear over the last 3 years?
At the time, they told me that they had a miscommunication with the case that they put retail fraud when it was attempt retail fraud, and they never made a adjustment on the case. I don't know what that was about, but it was attempt retail fraud, not retail fraud.
No, right. So, but I don't understand how that affects you appearing for your probation appointment.
No, I'm saying, like, why would I go to probation if there's like, I'm going to go probation for something that's not accurate on my.
Because you were ordered to participate in probation.
I'm saying, but it's not accurate.
Okay, so what did you do to try to correct it or bring it to?
Probation officer and ask him to switch it and fix the thing that was on the, the paperwork, and he never fixed this.
And how do you know that was never fixed, ma'am?
I looked on the case online. It never said attempt retail fraud, it just says retail fraud. It never said attempt retail fraud.
Okay. And so, ma'am, so then you thought it was the best practice to just ignore it?
Not ignoring it. Like I said, I fought numerous times, never got a call back.
Did you come up here?
No, I didn't come up here. I just gave the call back.
Right, so if it was that important to you, ma'am, why didn't you come up to the court?
This is my first time coming to the court. I never known that.
And I'm not sure what you're looking at because I'm showing attempt. I'm showing right on your criminal history, ma'am. It's showing attempt.
Well, that didn't say that in the online.
So
online said retail fraud. It never said attempt. When they sent me the link when I just tried to do a background check, and never said attempt retail fraud. It said retail fraud. So.
Well, I'm looking right
That's
at
the
it.
only reason I'm up here because I had did a job and then the background check like popped up for me to do a background check and it said retail fraud, not attempt read.
Well, that's interesting because it's also suppressed because of the HIDA status. So I have no idea what it is you're looking at or not looking at. But in any event, you took 3.5 years or 3 years to take care of this.
That's when it's inaccurate, like when they were nothing was being stolen or anything. So I'm just trying to see how can we proceed in a proper manner. I know the attorney said, hey, the fine and then probation.
Well, the recommendation is for probation to be revoked and under advisement to be revoked because you didn't do anything that you were ordered to do, ma'am.
That's what I'm saying. He said just pay the fine and then probation. Correct.
That's not how that works. Just pay the fine and then probation. The recommendation is to revoke probation. You didn't participate in your economic crime program. You didn't participate in your random testing. You didn't participate in workforce.
Random testing for.
One of the conditions was random testing, ma'am. And you didn't, did you resolve your outstanding, did you resolve your outstanding warrants?
I'm working on that as well.
Okay.
Go through the list of warrants I have to have been.
So in July of 22 is when this court sentenced you to those conditions, and you didn't do any of those. Sorry, it was August 15th of 2022.
They like numerous tickets off. You talking about like civil warrants, like driving?
Ma'am, all of the warrants. You had 6 warrants for your arrest.
And I've been paying all of my tickets off. If you go through my civil warrants of driving, I've been paying for numerous warrants off over $3,000.
Okay.
Over.
And that's good, ma'am. But this court ordered you to participate in probation and you didn't do anything. You didn't appear at probation appointments.
Right.
You didn't do anything. So, counsel, why should this court not revoke the under advisement status and not revoke probation and allow your client to continue when she didn't do anything in the last 3 years?
Your Honor, I'd only ask you to consider that she does have a strong caliber job, and I think that, there was a little ambiguity there. I wish that obviously we could go back in time to get this solidified in a different manner, but she's still in a position where she can clear her balance with the court, I believe, in a relatively efficient manner, and I'm concerned that if it were just to be revoked immediately or put into jail, progress that she's made would be halted. So I'd ask that she be just given a review date on this particular matter to see what sort of progress she makes, because obviously the admonishment of jail or probation being revoked can be implemented at any time. I'd ask that she be given one final opportunity to demonstrate full compliance with this honorable court. Thank you, Judge.
Can I speak?
What's that, ma'am?
I said, can I speak?
What's that?
Like I said, I have been paying over numerous amounts of tickets that like a lot of numerous of my money has gone to. Like I said, my license has been suspended for time, maybe over 5 years. And I put like a lot of money towards that. So you can pull it up into the system. It's been Southfield, Lonia. Like I said, I might have ignored this situation, which I could have did, multitasking, did multiple things, but it's only so much I can do with just working at UPS.
I understand as far as the payments, right? You have limited income. However, you didn't do anything with probation with this court because you had some information that it was the incorrect plea or charge that was on your record. So instead of coming up and meeting, had you met with your probation officer on those 2 dates, you could have addressed that.
I told him that.
But
it was Zoom. It was like in.
Either way, you didn't show up November 9th at 22, you didn't show up November 29th at 22. Here's what I'm going to do, ma'am. You're getting one chance.
Okay,
That is it.
okay,
The court's going to order your probation to be reinstated or continue probation 12 months. Complete all terms previously ordered. $15 days jail. Suspended. Will continue your under advisement status, which will be revoked if any violation.
the 15 days, you said start after the 15 days?
I suspended it, ma'am. If there's a violation, you'll be doing those 15 days.
Okay.
Okay. Stop at probation. Somebody will be with you shortly, and we'll go over all of your terms and conditions that were previously ordered. We're going to require you to do all of those. Have a good day.
Thank you, Judge.
All right, let's go on the record in the matter of the state of Michigan versus James Benefield, 251081. And Detective, your name for the record, please.
Detective Dane Haskin, Haskin, City of Riverview.
Great, thank you. And I believe that I've already signed the warrant. And so, counsel, your appearance for the record, please. Mr. Shemke, am I muted? No?
Somebody's muted.
No, we can hear you.
Okay. That's right, you all did just respond. Mr. Shemke? All right. Your appearance, please, counsel.
Good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
All right. And so, Mr. Benefield, your name for the record, please.
James Benefield.
Okay, and today is the arraignment as Mr. Benefield is in custody and counsel as to the arraignment.
Wait formal reading. My client stands mute.
The court will waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. And you've in fact had an opportunity to meet with an attorney today. Is that correct?
Yes, ma'am.
The court has also signed the petition for appointing the attorney for felony matters. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. And do you understand all those rights, sir?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for a probable cause conference on February 5th. 10:45 a.m. And counsel, as to bond.
Your Honor, my client indicates that he's been in MDOC for a significant amount of time. I think anywhere between 13 to 17 months. That's why he didn't make his last court appearance, but he did just make parole. He is on a GPS tether upon release. He does have a strong family support system. He can reside with his brother in Southgate, and he does have a job opportunity. So I know at this time, Judge, with him being in for such a significant amount of time and with the GPS tether, I think that the risk of absconding is minimal. So I would be respectfully requesting consideration for a personal bond. I know that down the road he might have some financials, but with him being in custody this entire time and now having an opportunity to rejoin society and have employment, right now his financials have a serious constraint. Thank you, Judge.
Okay, thank you. And, sir, when were you, granted parole?
Yesterday,
Okay. And what were you in, prison for, sir?
for, carrying concealed weapon. Matter of fact, I have to report as soon as I get through with this matter here.
And how much time did you serve for carrying concealed weapon, sir?
16 and a half months.
And that was the only charge, sir, that you were serving time for?
I believe it was a fleeing and eluding as well, and receiving, fleeing and eluding and CCW.
That would make more sense as to just the CCW because, it sounds as though it was more than not to minimize the CCW, but it sounds as though it's more than, simply a CCW. And is that out of Dearborn or Taylor, sir?
It was out of Dearborn.
Right, in that matter, you were charged with CCW, attempt felony larceny from a motor vehicle, felon in possession, another felony firearm, possession of burglary tools. That's everything that you were charged with, correct?
Correct, and everything was dismissed for a plea to the CCW.
Okay, and so when did you do all that, sir? Because that case is from 2021.
I did that in 2021, and then I went to prison and I was on parole and violated my parole in August of 24, and I've been in custody since.
Okay, and so the court will know that August of 24 is about 2 months after the date, or 6 months after the date that this incident's alleged to have occurred as well. And the court will also note that, let's see here, you have another from 23 from Farmington Hills, Sixth Circuit Court, pled guilty to felony unlawful driving away of a motor vehicle. February of 25, receiving, concealing stolen property, Third Circuit Court. And fleeing elude third degree. Is that what you were just in custody for, sir? Or is that this is the one from 24? So is this the one from?
I was in custody for parole violation, and I had those warrants. I took care of those warrants, and they gave me time served. Time served.
All right. Well, and then it also appears though you have a significant criminal history down in Texas. Correct?
Yeah, correct. That was when I was 19. That's 30 years ago, 35 years ago.
Okay.
30-something years ago, ma'am. Your Honor.
And now you're also charged with also habitual offender fourth offense as well. Correct?
Yes, ma'am, correct.
And
you know, I thought this time I've been incarcerated, I've took a lot of classes and you know, trying to better myself, you know, learn from my mistakes.
all right, well, do you know Liam Toohey?
Liam Toohey?
No, ma'am, I don't. No, ma'am.
Okay. Well, sir, I hear what you're saying, but the court has some serious concerns for the safety of the community. While it may not seem to you as though these are very significant because they're not, you know, crimes of violence against a person, this is still a continued deprivation of individuals' property, and where it seems though you continue to try to help yourself to items that do not belong to you and they belong to other individuals. I understand that these are allegations in this matter and that this occurred prior to the other matters even incarcerated for. However, the court still has an obligation to the community to ensure safety of the community. And therefore, the court's going to order a bond. Detective, did you want to address bond before the court continues?
Yeah, just a quick update. Within about the last 10 minutes, we received a parole detainer from Wayne County. So the defendant does have a detainer waiting for him.
But he was just released yesterday?
Just released today.
Yeah, I'm not sure what his parole officer was doing, but we were advised yesterday by Macomb County Jail that he was being released. We agreed to pick him up on his active warrant and lien, and then we just received the parole detainer a few minutes ago.
All right, well, okay, that's interesting information to know as well. The court's going to, especially taking into account the habitual offender fourth offense notice, and that upon conviction, if there's conviction, based upon the charges of Mr. Benefield's looking at up to life imprisonment. So the court's going to order a $100,000 cash bond. No 10%, no surety. With the following bond conditions. In the event you do post bond, or even if you don't post bond, you're still not allowed to have any contact with Mr. Toohey. That's phone contact, text message, email, social media, third party, anything of the like. Same with prosecution witnesses. You're not to go to Mr. Toohey's place of employment or address, and since you don't know him, it shouldn't be very difficult to avoid him. Not to possess or consume any alcohol or drugs unless prescribed, not to possess or have access to any firearms or weapons, not to be released without a GPS tether from Wayne County Jail. Thank you. Have a good day.
Thank you, Your Honor.
Thank you.
Man, oh man, how bad can it get? Well, ladies and gentlemen, that's how the cookie crumbles. That's all I got for now. I got a lot more stuff to go through, but that's what I have put together for today. I saw the boy earlier this morning when it happened live, and I just thought to myself, that's something I need to share. And of course, the Simpson, Tope, and the McNally were gimmies. I mean, that's just I wanted to tell the story of Mr. Bogus with McNally, though. I felt the other videos I had seen had not necessarily really put it out there how much he had really kind of made himself present in all of the cases leading up to his. And then his case, oh my lord, his case. And then, yeah. A lady who hasn't shown up to court for 3 years, and a guy who's looking at life in prison who just got out of prison yesterday, and now he's on detainer again. Oh my goodness. Ladies and gentlemen, I want to thank you very much for tuning in with me tonight and commenting on these myriad cases. It's been interesting, and as everyone in the chat is saying, yes, I can read. That's how the donut rolls. Unless the donut has its hole, and then the donut rolls a little different than when the donut doesn't have its hole. But ladies and gentlemen, I am your Lone Wolf Oozle. And I want to thank you very much for hanging out with me. Y'all have a great night. Go check out all of our friends. Coolin' with Colin, Hutch over at Sovereign Legal Encounters, and Mike at Mike's place, and Biggin at Biggin's place, and OSG at OSG's place. And for God's sakes, come back and see me tomorrow night at 8 o'clock Central Time, 9 p.m. Eastern. because I do this every single night of the week, and we have about 2 hours of daily court cases from the day they happen. At least I try to at my best. Sometimes we've got to watch some stuff from the past to get caught up on the things happening today. Anyway, I am your lone wolf Usul. I am your curator for these here videos. I am your humble servant, and I am your host for these here get-togethers. And I am going to say thank you very much, ladies and gentlemen. Good night. I am out. Bueller. 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 Mark him absent. And now, east of the Rockies,